I mean, it's a good question. I was taught that a student cannot be labeled as emotionally disabled and specific learning disabled at the same time. That one trumps the other in regards to law under IDEA. Can you elaborate on this? Now, there could be specific differences in the law depending on the state that you live in. And so there could be some fine nuances, so you're going to need to check on that. But the general policy with regards to the federal rules is that, there would be really no purpose if if the child qualified in one specific area, then it is the IEP's responsibility at that point. The only sort of exception to that rule would be if a child is identified as speech language impairment only. Okay, because at that point, and this is a unique area, if it's specific, if it's the speech language impairment, then it sort of assumes and denotes that the only issue your child has is in the areas of speech and language. And therefore, the case manager that is assigned to your child is going to be the speech language pathologist. Now, speech language pathologists have a role for the other categories as a related service provider. But when they're addressing a speech language impairment, then they are the service provider. They are the case manager. They're basically assuming the role of the special education teacher or resource teacher at this point. Whereas with all the other disability categories, they're related service providers back here to support the child. And the special education teacher is the case manager. So that's the only category. So let's say the child qualifies for emotional disability. Now, does that mean that we just ignore the other educational performance areas of academics or communication or transition services or maybe functional skills? Absolutely not. So the child got their foot in the door. The child qualified under one of the 13 or how many categories exist in your state. And at that point, the ball is in the court of the IEP team to sit there and design services not based upon the child's label, but based upon their disabilities, based upon their deficits, and based upon their needs. The label itself, what the category is that they qualified under, that just got them in the door. A FAPE is connected to the child's disability, which isn't necessarily the label that they qualified under. Now, do they need both diagnoses or do they need both categories in order to qualify for services? No, they do not. No, they do not. Now, just because schools are stupid and they misapply or they misinterpret or they don't do the proper analysis, that's correct. But it doesn't mean that that's correct. It doesn't mean the law supports that. The label and meeting the minimal requirements for eligibility is the ticket and the way in. At that point, the IEP team has a responsibility to look at everything, to look at all areas of the child's needs. And that extends outside of the specific category that they may have qualified under. Like I said, the only one where I can see where there are going to be some legitimate hiccups is with that speech language impairment. And that's only because of who takes the lead in the specialized instruction, and that's the speech language pathologist instead of special education. Now, should the IEP team consider everything, even with an SLI? Absolutely. I just wanted to throw that in as a clarification. So, with your particular question, unless your state law, says, which it can't be in conflict with the federal law. So the part that I just explained about the analysis would be absolutely correct regardless of where you live. But what I'm saying is that in many states you can qualify, for multiple categories. Now, in the federal law, we have something called multiple disabilities, and that means that the child qualified for more than one category and met the minimal requirements in multiple different categories. Now, I've never understood the benefit to the child of being deemed multiple disabled. I don't see the point. In fact, I see it more of a hindrance and as more of a mechanism for justification for a school system being more restrictive, lowballing the goals, and engaging in what I consider the soft bigotry of low expectation. Okay? So I'm not a big fan of deeming children multiply disabled or multiple disability when one does the trick. Got the child into the door for the IEP team to do the full analysis and consideration of what their disabilities are, and that can be multiple disabilities. And then what is the peer-reviewed, scientifically known approaches for their particular learning style, covering all of their educational performance areas. So a child with an emotional disability likely is going to have need in academics, and vice versa. A child with a specific learning disability more than likely are going to have components, if not all of the components, for an emotional disability that could include anxiety, things of that nature. To sit there and say that our children exist in a vacuum and, well, emotionally disabled children just don't have academic need, that's horse crap. They do. That would be ridiculous. But understand that anybody who is sitting there saying, well, they've got to sit there and meet another discrepancy standard, they've got to sit there and qualify for these services. No, they don't. If they qualified under one category, they're open for the full analysis of services. I hope that answered your question. It's a good one, though.